Well, in the fast-paced business environment that we all live in now, maintaining a high-performing and stable team of employees, of course, is vital. Injuries and illnesses are inevitable at any point in time, but they can impact on businesses' momentum in more ways than one, and, of course, even more so when that absence is extended or indefinite. A recent decision of the Fair Work Commission has shed light on how employers should appropriately manage injured employees. Our regular workplace law commentator, Joydeep Hor, Managing Principal of Specialist Employment Law firm People and Culture Strategies, joins us now to discuss it. Joydeep, great to have you on the program.
Thanks, Brooke.
An age-old problem, I suppose, for employers, and a difficult issue that people navigate all the time. We've got the case study today of BHP Coal, so tell us a little bit about this recent case.
Yeah, it is very much an age-old issue, and one that employers are, I think, understandably quite reluctant to touch. In this particular case, and a situation that I think a lot of employers will be able to relate to, BHP Coal had an employee who had taken a significant amount of sick leave, was away for sort of an 8-month period. They were trying to work through a process. All that particular employee was providing, both through his general practitioner and a surgeon or a specialist, was a very high-level medical certificate that was not going into any of the information. BHP said, well, look, we actually want you to undertake an independent assessment from a doctor of our choosing that we will pay for, and employers have the right to do that. He did not want to participate in that particular process and effectively said that he would not do so, was quite belligerent. BHP said, well, hang on a second, we feel that we can direct you to do that as your employer. He failed to comply with that direction. They made the decision to terminate his employment. He challenged that by way of an unfair dismissal claim, and the Fair Work Commission ruled that no, actually, BHP as the employer in that particular case was within its rights to issue that particular direction.
And something I imagine is quite common is this issue, which you kind of alluded to. He provided medical certificates where there was no information about the nature of the industry or any kind of rehabilitation. So the employer's left wondering, well, can we ask for that information? You know, is it going too far? For what, for privacy reasons?
Exactly.
What are we allowed to know here?
Yeah, I think this whole area is problematic because it sits in that middle space between discrimination laws and regulations and also work health and safety obligations. So an employer, on the one hand, has to ensure that people's health, safety and welfare at work is something that is a paramount concern. If someone has an injury, the employer's got obligations to make sure that they're not going to exacerbate that injury by working. So that's why an employer is within its rights to say, well, we want to talk to your doctors, we want to understand the nature of your condition, if for no other reason, but just to make sure that nothing that we're going to ask you to do or require you to do is going to make you worse.
Yep.
On the other hand, the employer's got obligations not to discriminate against that employee by treating them less favourably as a result of any medical condition. And so what has happened over the years, in my experience, working with a lot of employers on this issue, is that employers often will just put this in the too hard basket, and they get these certificates which are very vague, but they feel that they can't do anything about it. And I think what this case really does do, and why I think it's a very significant case, is that it should be giving employers a little bit more comfort that you can ask the question. And whether you decide to push that to the form of disciplinary action if a person doesn't cooperate, at least this case says, look, you can push it probably a lot further than what you currently think.
How black and white is that, though, or is it still very much a grey? I mean, after day one, can you say, actually, we're going to need to chat to your doctors, or does it take 3 or 4 months and then you have to, you know, where are lines drawn?
Yeah, I don't think there's a precise time limit. The circumstances, such as how much sick leave does the employee have available. So, for example, if a person's been working for a long period of time, they've accrued a lot of sick leave, well, that's a right that they have at law to utilise that. I think it's only safe for an employer when it's got to a point where there is absolutely no certainty, no information being provided by the employee. The employer, if they can show or prove that it's having an operationally negative impact on its business, that will usually also be a catalyst for them to be able to push this a little bit further.
Okay, what happens when the employee then does come back to work? Are there sort of different obligations the employer's got to be aware of at that point?
Yeah, so under a lot of workers' compensation laws, there's an obligation for the employer to look at rehabilitation, look at restricted duties, all of those kinds of things. Where this becomes interesting is where the injury or alleged injury doesn't actually have any connection with the workplace. And this has increasingly become an issue. So employers will say, if it's work-related, we'll deal with it in one way. But if it's not a work-related injury and it's something that's happened to someone in the course of their private life or because of a hobby or a pursuit, then really should we have to pay the price for that as an organisation by accommodating that and bending over backwards? So lots of things for employers to think about very carefully in managing this issue.
Right, or in a sense, has someone just made themselves unfit for work and therefore, you know, we don't have kind of no obligation in that sense?
Exactly, because it would sit outside those workers' compensation obligations.
So talking about these kind of long-term absences then, which is, I guess, what this is addressed, do you have precautionary steps that you say employers should take? What's your advice, having watched these kinds of issues play out? And, as you said, based on this recent Fair Work Commission judgment? I
think my single most important feedback to employers is don't do nothing. Make sure you're doing something. Acting early, communicating with employees, making the expectations clear that this situation of rolling medical certificates where the employer is not going to be taking an interest in it is not the way the employer is going to handle this particular issue. It's not just about sending messages that are punitive or threatening, it's about showing that the employer actually takes an interest, both for the employee but also the employees around that employee. And the business has a right, the employer has a right to ask questions, seek information, and if it doesn't, this issue is going to fall into that category of a court or tribunal potentially saying, well, you didn't do anything about it for 3 years, why all of a sudden did you wake up one day? And the employer would rightly think, well, surely 3 years is enough, but the counterintuitive response is, well, why couldn't you have let it go for another 6 months or, heaven forbid, another 3 years?
Yeah, understood. Very difficult issue. Thank you very much, Joydeep. Thank you. Appreciate that. Yeah, that recent case shedding a bit more light, I guess, for employers on that issue. We have